Hello, my name is William Steinwhittle, and I am a staff attorney with the Foreclosure Legal Assistance Project for Maryland Legal Aid. Today we are going to talk about motions to avoid lien. We're going to focus on three topics: what is a lien, how it can be avoided in a bankruptcy, and additional issues that you have to take care of after the motion for avoid lien has been granted. The first topic, what is a lien? So before you file bankruptcy, you must check if you have a lien against you or liens against you. Liens generally fall within three categories: judgment liens, consensual liens, and tax liens. Judgment liens are liens that result from the receipt of a judgment from state court, generally district court or circuit court. The second type of lien is a consensual lien. Consensual liens are where you've agreed to make the payment, and perhaps the lien has been imposed so to make sure the payment is made, such as a mortgage or a car, or the lien is a result of because you haven't made the payment, such as an HOA or a utility. These liens, you will generally find if they exist, they will be on land records. Luckily, in Maryland, all land records are electronic, so you can go onto the Maryland land records site, it's free of charge, and see if a lien has been recorded against you. The final type of lien is a tax lien. Tax liens result from debt that is received from the state of Maryland or another state or the IRS. Tax liens are not avoidable in bankruptcy because they attach to everything that you own: your house, your clothes, your car, etc. So since you cannot file a motion to exempt everything that a person has, these liens are not avoidable. The second item we're going to discuss today is how you avoid a lien in a bankruptcy. There are two ways that you can avoid a lien in a bankruptcy. A judgment lien can be avoided in both a Chapter 7 or a Chapter 13 by filing a motion that says that the judgment is impairing your legally allowed exemption. Basically, what you have to show is that your legally allowed exemptions are impaired by the judgment lien itself. So basically, it's a math problem. So if you have $20,000 worth of exemptions and you have a judgment worth $7,000 and you can only take $13,000 worth of exemptions on the property because of the judgment, then you can use this exemption. You can do this motion in either a Chapter 7 or a Chapter 13. It's best to file the motion as soon as possible in a Chapter 7. In a Chapter 13, it must be filed before the case is confirmed. The motion must contain the servicer of the debt, and it must contain how much the debt is and when the judgment was entered. All of these things must be attached to the motion itself. In addition, you must serve the registered agent of the creditor any counsel that the creditor had in the original case, and via certified mail, you must also serve the president if the creditor for the judgment lien is a bank. It's always best to consult with an attorney before filing for a motion to avoid lien, although there are samples available with the court, and so there are programs that will allow you to look into how to file a motion to avoid lien as well. So it is very critical to do this correctly, because if you do not do this correctly, the motion will be denied by the court. The second type of lien that you can avoid is a consensual lien. You can only avoid these liens in a Chapter 13. You cannot avoid them in a Chapter 7. What you have to show in the motion is that the lien, the HOA lien, the utility lien, or the second mortgage, is unsecured because all of the equity in the home, and it is done only for residential real property, all of the equity in the home is taken up by the first mortgage or any preceding liens. A motion must contain all of the liens on the property that precede your lien. So if there is a first mortgage and a second mortgage, and this is an HOA, you must describe and point out on the land records where the first mortgage and the second mortgage is. Then you must show that the property value is less than the value of the preceding liens or first lien. This generally requires an appraisal or a market analysis from a real estate agent. Redfin and Zillow may be effective, but some judges do not believe that they correctly reflect the value of the property, so you may have to seek out an appraisal or market analysis. You must also have a notice and set a hearing date. This is also true for the judgment lien as well. The notice must be served and the motion must be served on the creditor registered agent. You can investigate the registered agent by going to Department of Assessments and Taxation and look up business entities. You must also serve the president if the creditor is a bank, and you must also serve any counsels for the creditor that have entered their appearance in the bankruptcy case or entered their appearance in any preceding cases. Generally, the court will grant or deny your motion before the hearing. If they deny your motion, you must fix all issues that the court has raised before the motion is granted. Generally, this will require you to file another motion. If the other side opposes your motion, you will then have to prove that the lien is avoidable. This generally would require the testimony of a real estate professional. So if you have not gotten an appraisal before you file the motion and it is contested, I urge you strongly to do so thereafter. A couple of notes on stripping liens. The first is you can strip a case without receiving a discharge. However, the strip is only entered in a discharge case once the plan is completed. If your case is eligible for a discharge, you will receive the lien avoidance once the case has been discharged. A judgment lien, no further steps have to be taken. In a consensual lien, you will have to record this land with land records. Generally, there is a fee associated with that, and I urge you to consult with your local county on the fees that are required. In addition, to strip a lien, all parties that are on the lien in a consensual lien situation are required to be in the bankruptcy itself. This is not a requirement for judgment liens. Lien avoidance is very complicated, and it can be difficult. I urge you, if you are an attorney, to consult with a more experienced attorney before filing anything with the court. If you are not an attorney, I urge you to consult with an attorney before attempting to do this on your own. Thank you, and best of luck in your bankruptcy and in going forward in your financial situation.